All right, well, I'll tell you what, I am so excited to have a conversation today with the Deputy Director of the United States Patent and Trademark Office, Deputy Director Derrick Brent. Deputy Director Brent, thank you so much for joining us today.
Oh, Luke, it is my pleasure. And anytime I get to touch base with you is a pleasure. And also anytime I get a chance to touch base back with anything connected to my alma mater city of Columbus, I'm always pleased.
Absolutely. Well, yeah, anytime you want to get back to Columbus, we welcome you with open arms. But it's so good to see you here on Zoom. And I'll tell you, I'm really excited for this conversation because I think we're going to touch on some things that a lot of people don't really understand around how student athletes need to make sure that they're protecting themselves through intellectual property protections. And we'll get into all of that in this ever-changing, rapidly changing space of college sports, and in particular, name, image, and likeness and beyond. So really excited for the conversation. But I have to ask you first, Deputy Director, can you please explain to the audience what exactly is the United States Patent and Trademark Office? Some people may hear it as USPTO, but the United States Patent and Trademark Office, what is it and what do you do as Deputy Director? What are we talking about today?
Oh, absolutely. Listen, again, I can't thank you enough for the invitation to have a chance to chat about the important NIL landscape. And it's funny, you and I caught up last year, and we've talked a couple times subsequent about these important issues. And then ever since we talked, it's still changing, even in the most recent iteration. So it's amazing. The United States Patent and Trademark Office is the home of intellectual property for the federal government. And that's probably a simplistic way of putting it. Intellectual property rights are rooted in the Constitution. The patent right and the trademark rights are expressly rooted in the Constitution. And the office was created to fulfill that constitutional duty. Now let's break it down just into a little bit more simpler and everyday meanings. So we handle the granting of patents and the registration of trademarks, and then we handle policy areas. We are the primary policy advisor to the president through the Secretary of Commerce on intellectual property issues. And in fact, we're the primary place that advises the entire government on intellectual property issues. And we engage with our friends both in the judiciary and in the legislative branch in Congress. The granting of patents. A patent is a thing that is basically an invention. It is something that is new, novel, and non-obvious. It is something that is basically an invention. We think of things like cars or parts of cars, or we think of a golf club. There are many different things. Things that have a utility are patents. Trademark is more about branding, which is what we will probably get into quite a bit today. And trademark is basically a logo, a phrase, a coloring scheme, all these things that draw meaning back to your business, to your service, or to your good, a product. So the most famous one everybody thinks about is the Nike swoosh. You can see just the swoosh. You can see Nike in a certain logo or a color, and that's a trademark. And with patents and trademarks, we grant the patents, and you get a certain term of time where you have the exclusive right to make or manufacture your product. And after that time, then it goes to the public. But in exchange for that right, that monopoly right to make or use your product, you also have to disclose your product to the public. You have to disclose your invention and how you came about it. Trademarks, you register them. They have a period of time, and then you can re-register them. And they're good. They're valid as long as you keep using them in commerce, as long as you keep using them in business. So we handle the registration and the granting of those rights. And then we also develop policy helping to make those rights enforceable and make them usable by the public.
No, that's great. Yeah, that's fantastic. And I think it's helpful too, because oftentimes to the average person, they don't always know the difference between a patent and a trademark. And so to hear that, I think is incredibly helpful. So we're going to get into the how, like, how does this work? How does this happen? But before we do that, I think it's important to even just talk about the who, right? So as we've kind of discussed over the last year plus, the pace of change in the college sports landscape is so incredible. And I think we have to understand that at the root of all this are student athletes who have now turned entrepreneurs, student athletes who now are trying to manage this business kind of around them. As you kind of look at these changes and you start to think about, kind of some of the challenges that student athletes are facing, both through your lens at the U.S. Patent and Trademark Office, but also just in general in seeing kind of, being a part of government and seeing these changes happen, kind of what are your thoughts? What are your thoughts as we think about now these student athlete entrepreneurs and the challenges that they face?
Yeah, and I think that's a bit of a long title, the student athlete, entrepreneur. But quite frankly, that last part is important because before, we had students, students and athletes, and that job was hard enough. If when I attended Ohio State, I got to know some of the folks in the athletics program, and I actually worked in the athletics office for a year in work study, actually maybe 2 years, I think. And it's incredibly hard. You get up, you work out, you go to classes, then you have practice, you have training, all of that stuff. Well, now in the new landscape, we've now thrown on top of it, and I shouldn't say we, but now on top of that, student athletes are now being asked to really engage in business decisions and to really know about business at such an early age. I mean, you really have to know about this. Those student athletes and their families need to know about the business side, whether it's financial dealings, financial literacy, but also intellectual property issues, how to form a business, why you might need to form a business around yourself. All these things you have to start to this when you're in high school. And now when I was in high school, I wrote a song and I got a copyright for it. And so that was great. And I thought that was really advanced. What student athletes today, it is really important because with NIL, with what is coming on coming down the pipe, with the recent settlement that is coming into play, student athletes are now in a position where, whether they're going to have a professional career or if they are going to just go on and do their own, do a professional career, but also be able to have not a professional athletic career, but if they're going to be professional entrepreneurs, if they want to have that option. And what's important to us is that making sure that you protect your intellectual property rights so that the hard work that you're doing to build your brand, to build yourself and your business, all of those things are protected so that you have control over them as you go forward and you're negotiating around them, and that whatever enterprise value that they're giving to you is properly assessed and properly negotiated.
Yeah. So listen, first I'll tell you, I'd love to have you perform that song that you wrote in high school now, but we'll save that as a teaser for the next time we have this conversation. But you're absolutely right. The challenges that student athletes face now, because they are also that entrepreneur, it is now so incumbent upon student athletes and the institutions that they're at to ensure the education around all of these business aspects that are now impacting their lives on a regular basis. And to your point, whether that's understanding contracts or understanding budgeting and financial literacy, most certainly taxes. But another piece of that is also making sure that if you are developing and building your brand and you're putting your brand out there, especially for commercial purposes, you want to make sure that you protect that brand. So let's maybe talk about that a little bit. When we talk about name, image, and likeness and this rights of publicity that student athletes now are able to commercialize or able to monetize, what does that look like from a protection perspective? From IP trademark protections in particular, what does that mean? What does that provide a student athlete? What are maybe some examples of why a student athlete would want to or should protect their IP versus maybe not? Maybe shed some light there, and I'll share some perspectives as well from what I've seen with pro athletes as well as some college athletes.
I was going to say, Luke, and this is an area where we're definitely, both of us have seen things in our professional lives and can share some perspectives. It starts with, I think, what are the rights? What are the rights? So we're going to start in the high end and the technical part, and that is a trademark. Now, remember, I talked about a trademark. Trademark is logo, color, a phrase that references a business. It references a business. So you can't just, it's not just that you're a good athlete and you have a clever nickname and you get a trademark on that. It's you're a good athlete, you have a clever nickname, and you want to apply that to apparel, or you want to apply that to your business that you form. Now, so why is that important? That's important because it's an asset. And that is what I think student athletes and families need to understand, is having that trademark gives you an asset, so that when somebody is putting a contract in front of you and they're saying, hey, we want you to do promotion for us, well, they're asking you to do promotion, but they are also asking you to put your goodwill, aka your trademark. You put your trademark on the line. You're putting your brand on the line as you support a project. And NIL, a lot of it, the use of name, image, and likeness, is discussing promotional opportunities. It deals with, I should say, it's dealing with promotional opportunities where student athletes are being asked to do promotions on behalf of businesses. So your trademark is something that enhances the value of the promotion. And therefore, as you're negotiating as a student athlete, as an entrepreneur, any entrepreneur would say, if you're negotiating to use my service and you're negotiating to use my goodwill, the brand that I have built and the people who are following me because of this, then there's a certain value for that. And that's where the intellectual property right comes in. Very similarly with the rights of publicity, the right that they have to use your likeness, the right that they have to use your image, the right that they have to use your name, combined with your trademark right, your branding that you've protected, you put all of that together and there's a value to it that you want to share. So for the athlete, and one of the things, and I know we're going to talk more about this, is it is important to make sure that you have all of that wrapped up and protected, so that as you're going forward, not only when you do these NIL deals in college, and by the way, the NIL deal doesn't have to be the really high-end deal that you hear about, the multi-millions or the cars or anything. The NIL deal might be just a nice little small deal that you're doing, that, where it's going to take some, it's going to take some of the pressure off of tuition. This is a wide-ranging thing. We can't always just think about the high end. We have to think about, the opportunity that's here for even smaller deals. But what's important is, as you go through those deals, protecting your trademark, protecting your publicity rights, and making sure that you're getting value for those, and making sure you have some level of control to use those afterwards in case, as you go on in life and you want to do things related to your brand. So that's a very quick example. Luke, what have you seen? You've worked with a lot of athletes on all levels.
Yeah, absolutely. You're spot on. And when we look at professional athletes and even college athletes from an NIL perspective, there's some misconceptions. And one is that I've got a great nickname, so I'm going to get a trademark so no one else uses it, right? Or I've got a cool kind of slogan. But to your point earlier, that has to then be applied to something in commerce, whether I want that to be a part of apparel, or maybe I want to have it as a name of a podcast, or something along those lines. There has to be something that you're applying it to. But I will say this: when we look at name, image, and likeness, I like to share with people, there's really two kinds of name, image, and likeness. There's the pure name, image, and likeness, which is student athletes that are licensing or lending for a fee the use of their name, their image, their likeness to a third party to help that third party, that company, that brand, that business to penetrate their market, sell more products, provide more services. But then we also have what I'd call more synthetic name, image, and likeness. And this is just the reality of what exists out there, that we know that there are NIL collectives, and those NIL collectives are typically put together to be able to encourage or solicit a student athlete to attend a particular institution or to remain at a particular institution. And oftentimes that looks a lot more like pay for play. But here's what I want to share with people, which is that when it comes to collective deals in particular, as a student athlete, you still have to provide a service. You still have to do something. And so that something is oftentimes you're going to do some type of social media promotion for that collective, or for companies or businesses that are a part of that collective. And so just like the deputy director said earlier, you want to still make sure that you're protecting your brand, right? Protecting your intellectual property rights, because even if you're just doing something smaller because it's coming as part of a collective deal, you want to make sure that you're getting all of the value and the protection necessary as you think about these opportunities in your intellectual property. Because we've seen it. I've seen deals already, bad deals for student athletes where someone, a company, oftentimes a marketing agent wants to then have rights to that particular athlete's name, image, and likeness in perpetuity, right? Or for a period of time long after they're done playing their sport. But we also know that student athletes can maybe not go pro in their sport, but become a professional, become an entrepreneur, become a business executive, get into acting, whatever it may be. And you most certainly don't want someone else to have access to those rights after you're done playing. So to your point, Deputy Director, it is really about finding the protection in all of this. And so, which I think kind of leads to my next question, which I think most families that I talk to, student athletes that I talk to, don't understand is kind of the how, right? We've talked about the why. It's so important because you want to protect yourself and there's monetary value there. We talked about kind of who we're talking about in terms of student athlete entrepreneurs, but now how does a family navigate kind of the trademark side of protecting their individual brands?
This is, and by the way, this is typical of our conversations. We kind of just feed each other. It's a little bit like a jazz combo session, and that's what I enjoy about it. I want to go back to one point, and it leads into this point, which is that the reason all of this is important, and Luke just really talked excellently about what is going to happen, how these deals come about, and different things. But what is most assuredly going to happen, whether it's that deal with a collective, whether it's a deal with a particular business, however that deal comes through, there will be a clause inside of there that will have something dealing with intellectual property rights. And so knowledge of, and it's going to deal with your rights of publicity. So having some knowledge about that, about those issues, and having an idea of how you're being compensated for those things is vital. It's truly vital. Now, the how of this. The first part is I'm going to give the age old thing. Please seek counsel wherever you can. And there are many different ways. There are law firms. But there are also we at the USPTO, in fact, for trademark issues, we have trademark law clinics around the country, and we have about 65 of them or more. And if you go to the law schools where these or contact the law schools where we have pro bono law clinics, if you meet a certain income threshold, they can look at helping you to file for a trademark registration. So that's one piece of the puzzle. We also have pro bono clinics around the country, and I know that the International Trademark Association is doing some pro bono work in conjunction with our pro bono programs around the country. So there are programs. There's a lot of lawyers collectives for the arts sometimes that can help out. So there are services out there that can help you. Now, the primary area, the rights to publicity, I should probably take that off the table a little bit, not take it off the table, but what I would tell you about those is those are your rights. Those are sort of your inherent rights that somebody cannot use your likeness. They cannot use your name or different things commercially without your permission. Right. There's common law rights, and some states have put it into statutes. So you have that aspect, and you have that, and it's your inherent right. So you know about that. On the trademark side, we have on our website, uspto.gov. We have excellent resources. We have one resource that is actually just for entrepreneurs, and I highly encourage folks to please read through that because it can tell you a lot of things as an entrepreneur of ways that you can work with intellectual property and ways that you can engage with the USPTO. But on the trademark side, you can either through an attorney or on your own, you can file an application. And in the application, you're going to be asked to provide an example of what your name, your logo, if there's a specific coloring that you use to it. You're going to be asked to provide a sample or a specimen of that. And then you're going to describe what the particular business use or the commercial use of that name or logo is. And you're going to explain exactly how it's going to be used. And that's the process. It's an application process. It is pretty much online these days. It is almost you can do the application through the site, and then the office will come back and it'll let you know if they need additional information. It's called an office action, and this sounds technical, but it's basically the process. You file an application. The office tells you either, hey, this is great, we have enough information, you're registered. Or the office will tell you, hey, we need a little bit more information about your commercial use and different things. And you will supply some more information. And then once you're granted that trademark, you will receive a period of time in which you have federal registration. No one else can use that in the same way that you use it. And so you get to go forward from there with your business. And that's really the crux of it. And so, and the key is, I would say, one, get counsel, get some counsel, but two, the trademark process. We have a lot of people that file their own trademark applications and will engage. If you can either use a counsel or not, but we go through the process and then you get yourself registered federally. It's worthwhile because there's a lot of protections that provides you if you need to actually enforce your trademark against somebody who's using it.
That's so great, and really kind of a lot of information there. I want to maybe touch on a couple different parts of things that you said. One, when you talked about, consider getting counsel. The one word that I add to that is competent, right? Consider getting competent counsel. What we're finding a lot of times with student athletes in the NIL space is that everyone wants to kind of jump in, right? And they see the opportunity of 500,000 college student athletes now that have the opportunity to earn compensation as a way into kind of having building a sports career. And so making sure that if you are talking to a lawyer, that they actually have experience in kind of filing trademarks and seeing that process through. And if not, identify someone who does have that experience, or as the deputy director said earlier, there are other resources that are available out there to lean on for that information. The other thing that I'll say too, and maybe you could shed some light on this too, because this question does come up from athletes at all levels as well, that when you file for your trademark, for that name, that logo, that phrase, at that point, once you file, you can use the TM on when you're using your mark now in commerce, or if you're using it on apparel, clothing that you've created once you filed. And then once it's actually registered, and what Deputy Director said about, you want to get that registration, once it's gone through the process and actually have gotten the registration, then you can use that R with a circle around it. So if you look at like a Coca-Cola, can or something, right? And you'll see Coca-Cola, and then you'll see that R with the circle around it. Or for student athletes that are listening to this, if you walk almost anywhere in your athletic department and you look at a logo or, the phrase of your particular school or team, most likely you'll see an R with a circle around it, because schools are doing the same thing. They protect their logos and their marks. So anything to add there, just in terms of helping people understand kind of how to show that they've started using a mark kind of in commerce?
Yeah, and that's excellent. It's an excellent tip. Because there are, again, getting a little log geek, being a little bit log geek. You have once you've started the process of registering your trademark, you can, when you put the TM beside it, you can signify to other people that, hey, I'm using this in commerce, and you can tell other people, like, I'm using this in relation to my product. Okay. So, it signals to the world, and you will have certain what they call common law or, common law rights. They're not as broad. Those common law rights they're enforceable, but the federal protections, and the reason why we tell people to go ahead and get the federal protection, is because they provide a broader range of ways that you can enforce and ways that you can protect yourself. So, but in the meanwhile, it is important to signal to the world that you are starting to use this, and you're using this name for commercial use.
Yeah. Now, do you want to share a little bit, maybe just because, again, just sticking in the how, I think it's always important to have the resources available to those who are listening. So if you go to uspto.gov.gov, there's a lot of resources available there. And one of them is being able to search the database of kind of what already exists out there. what does that kind of look like if someone says, hey, I've got an idea of a name, before I file, maybe I want to check and see if somebody else is already using that name. What does that look like?
Yeah, and that's a great point. And funny enough, real world story. I just had a conversation like this with a buddy of mine who is, he's a lawyer and he's an entrepreneur, and has some other, some businesses. And he was thinking, I've been walking around just doing this and promoting myself, and he goes, I need to protect myself. And he sort of asked me, he's like, can I search? Like, do you guys have a search database? And I was like, oh my goodness. that it's a great resource. So yes, one of the things you could do, again, for free. The great thing about the federal government, I'm going to step aside of this and make sure I come back to the search question. But one of the great things about federal government / and the USPTO is that we do provide a lot of our services for free. The actual registration, I have to say, the registration of patents and trademarks do cost money. There are registration fees and application fees. But for educational services or to figure out how to use things, we give a lot of free resources along with that. And for example, if you plug into our website, and that's for student athletes that are hearing this, for the families, it's worthwhile. It really is worthwhile, because you might decide to start your own e-com business for the family members. You might decide to start your own business or something, and it's worthwhile to know how to make sure that you're setting your business up right. But we have things like programs, like we have trademarks boot camps that will tell you how to go through the whole trademarks process. It will teach you about trademarks. We have programming that you can actually either see virtually, or sometimes they're live in your area. So please avail yourselves of that. The trademark search that we have is also an excellent tool. You come in and you type in your phrase, and you figure out, hey, I'm going to use this for shoes, or I'm going to use this in a very specific product, or I'm going to use this related to a business service that does a certain thing, does tax filing, a business that does, that is just an apparel business. Whatever it is, the business, then that will give you a bunch of results back. And from those results, you can see, is there someone that's using your proposed name, your proposed logo in a very similar way, or how close is it? And a lot of times, if there's something that's close, that might be a signal. Maybe let me go talk to a good, competent counsel. I like that addition. But it also may be that you see that there's nothing else out there like it. So then you can figure out, how do you want to proceed from there. And again, go seek counsel, good counsel if you want, if you wish. But also, if you don't see that, you're going to get the results back in a fairly clear way to show you what's out there. And sometimes, if you're using a name that's fairly generic, yes, you're going to get back a ton of results that look like it. And so that's the other, that's another aspect of it. But you're going to get that first look and know whether you have something that's very unique.
Yeah, absolutely. So this has been a fantastic conversation. There's so much information here that's going to be so helpful, I think, to so many student athletes, their families, but also even to, some of the professionals that are working in this space in college athletic departments that don't fully understand just this side of athlete brand protection. So thank you so much for your perspective. As we kind of close out here, any final thoughts that you may have, as we know that this is a rapidly changing space, but the one thing that isn't changing is that, trademarks, brands, et cetera, should be protected. But any other thoughts, Deputy Director, that you would share with our audience of things that they should think about?
Again, thank you very much for this conversation. It's fantastic, as I knew it would be. And I would share to folks, please do not hesitate to engage with the USPTO, the U.S. Patent and Trademark Office. We have regional offices all around the country, and we're just getting ready to set up a regional office for the Southeast region in Atlanta. We've posted for a new director, and that office will be up and running over the next year. But go see, contact our regional offices, or contact us directly here at the. We also, here at the agency, we also have, assistance centers that you can call in, and you can get guidance. And so there's a lot of resources out there. Student athlete entrepreneurs, their families, they have to be thinking about this. But also, as you said, and I love that you added this on, schools, administrations, athletic departments need to also be thinking about these issues and thinking about it, because ultimately, from our view, all of those groups are all stakeholders in our innovation ecosystem, in the IP ecosystem, and we want everybody to be able to work together. And so, for the schools and administrations too, please avail yourself of our resources, because we want to make sure everybody is able to work well, because when we all work well together, the country benefits and the country's economy benefits. So, we're here for you.
Awesome. I love it. Deputy Director Derrick Brent of the United States Patent and Trademark Office, thank you so much for joining us in this conversation. And thanks for all that you do.
Oh, thank you very much.